Kindly mute your mic and turn off your camera. And the question will be taken the last. So, respected ma'am and the dear participant, a very good evening to all of you. I, Rishabh, member of Legal Vidya, welcomes you all to the highly anticipated webinar on the topic Alternative Dispute Resolution. This highly anticipated event promised to be a comprehensive exploration of ADR method, shedding lights on their significance in the modern legal practice. With an expert speaker sharing their insight, participants can look forward to the gaining invaluable knowledge on the subject, enhancing their understanding of dispute resolution beyond the traditional courtroom settings. Before we begin the webinar, I would like to introduce our organization, that is Legal Vidya, that was founded in the year 2021 with the vision of empowering young lawyers. Our organization provides a comprehensive portal where people can enhance their knowledge and grow their expertise in the field of law. Our organization offers various opportunities such as internship programs, a platform to publish articles, and host interactive webinar and session with the law student. Now it is great pleasure and the honor that I introduce our distinguished speaker for the today's webinar, Ms. Mohan Dutta ma'am, a consummate professional in the role of HR and quality assurance manager at the Beyond Brief Law Review. With a wealth of experience and expertise in both fields, she has stand as a formidable figure in the realm of legal administration. She proudly holds membership of the American Bar Association and plays an active role in All India Human Rights Association and a distinguished member of the Young International Council for Commercial Arbitration. So, without further ado, let us warmly welcome ma'am to our virtual stage. We eagerly await the invaluable wisdom and the perspectives that they are about to share with us. Now, over to you, ma'am.
Thank you so much for a warm welcome and such a good introduction. Hello, everyone. This is Mohana Datta, the HR and Quality Assurance Manager at Beyond Briefs Law Review. Today, I'm here to enlighten all of you about ADR. So, I want this session to be an interactive fun. So, I'll be taking all the questions at the end, but in between, you can ask questions if you want. Okay. So starting with ADR, we all know that the full form of ADR is Alternate Dispute Resolution. Now I want to know from all of you that what do you mean by alternate dispute resolution? Anyone? It can be just a basic meaning. Am I audible?
Yes, ma'am.
Yeah. So anyone can answer. Just a basic meaning what you understand by ADR. Yes, outside court settlement, alternate way of settling disputes, solving disputes outside the court. Yeah, we can solve disputes without going to the court. Absolutely, yes. It refers to the various methods or processes that can be used to resolve the legal disputes outside the court. What we know as the traditional court litigation, we can solve any dispute, be it commercial, be it any family dispute, be it any international dispute. We can solve that easily outside court by using ADR. Now, ADR is also known as an innovative alternative to traditional litigation. Why? Because ADR has an informalness. When in court, we know we have to follow certain procedures, certain formalities. We have to adhere to certain strict guidelines. But when it comes to ADR, There are informalists as to you can speak according to your points. Sometimes it's not required to give certain proofs because in ADR you are negotiating with the other party. So over there, both the parties have to come to convergence, have to come to a point of settlement. Also, area has different kinds of methods. The most primary methods, three methods are negotiation, mediation, and arbitration. Now, in all these three methods, these are most cost effective than the traditional court litigation. Because when in traditional court litigation, there you have to pay your advocate daily for the daily hearings, and at the end of the case, you have to pay him or her. But when it comes to this ADR, using any of the three methods, this is much more cost effective because it takes you have to give a less amount of money and the frequency is less. Maybe the matter is being settled at the first call itself or the second call itself. And also, like during litigation, it happens that for the family disputes, generally for civil cases, we see that the hearings are given like once in 2 months, and then again after 3 or 4 months, it's given. So, when by the time the case closes, actually, okay, it takes up to like 9 to 10 years. Also, sometimes it takes up to 5 to 6 years. And if you're using ADR, it can settle in months. Okay, it won't even take as long as a year. So it's time effective also. It's quite speedy. Now, when it comes to confidentiality, area serves that whatever is being discussed within the boundary of that particular day or that particular call will not be shared outside. Both the parties have to maintain the confidentiality. Also, a person will be uh, a person who will be like employed as an arbitrator or as a mediator to resolve the disputes. That person wouldn't be able to share your your arguments, but your statements outside without your permission. Neither the opposite party, neither you, or neither your employed arbitrator or mediator. Now, again, another important effective way is that expertise of decision makers. So, when you are appointing an arbitrator or mediator for any case, be it a civil case such as a family dispute, over any commercial dispute case, or international trade or cross-border data case, in that particular thing, obviously you will employ or will put into effect a searcher person or a searcher mediator, professional mediator, or an arbitrator who will have expertise in that particular field or that particular area of the case. So over there, always it does not mean that whatever points or statements the parties are giving, we have to settle over that. Also, it happens that the mediator or arbitrator gives some creative points or some creative solutions so as both the parties are being benefited. It does not happen that one party is going at profit and the other party is somewhat compensating and running at loss. Okay, so it happens that both the parties are settling over some or the other, and both the parties are in benefit. Now, this area is such a process is not only applicable in India but also all over the world. And also, we see if the matter goes at court, okay, during the trial and everything, somewhere or the other down the line, our relationships or the professional relationships we share, be it for the company disputes, one client company with the other production company, or between two families who are having disputes, that tarnishes. The reputation goes down, or either the relationship they share that tarnishes. So in this matter, ADR helps to preserve those events. Now, I would like to say in detail about the three methods. Those are negotiation, mediation, arbitration. Also, in some cases, the method of mid-arb is followed. That is, like both the process of mediation and arbitration is being included to settle a dispute. The negotiation is generally a process which involves the involvement of only two parties in the consent issue. And as I have said earlier, any statement during the meeting which is said by either of the party cannot be taken to the court and used against the other party. Because as I said that this matter or this particular process involves confidentiality and benefits to preserve relationship and everything. Therefore, this statement, suppose your other party has given a statement which contradicts their own. It can happen sometimes because they also can have false and they are supposed admitting it that they are having false. Now, the matter did not settle and you are going to the court, you are moving the court for that matter. And now you're using those points and saying that yes, that person or that group of people has admitted that they have done this particular error, they have committed this particular mistake. So you cannot do that because this has to be confidential. I have already said about the cost effectiveness and the speediness of this process. So moving on to mediation. Now, mediation involves the two parties and another person that is the mediator. Now, about the consent issue, again, the same rules applies that like the statement given by one party cannot be used against that particular party when moving to the court if at all the matter is not being settled inside the meeting. Also, there is another person in between those two parties, that is a mediator, to mediate the problem, to mediate the dispute, to make them understand, to give them some certain solutions as to how they would get help, as they would get benefited by the process. And also, uh, mediation clause is being signed by the mediator from both the parties, including the clause includes that the about the statements thing, about the confidentiality, about some of the like if they are ready to settle the matter in the meeting or whatever it is, like it shouldn't be that you are not it shouldn't be that you are using some harsh words against each other. This is one of the etiquettes you should follow during a mediation process. You should not tend to insult the other party, keeping in mind you have gone there in a meeting with the other party to negotiate, to mitigate the dispute. Going on to the arbitration. Arbitration is also a process where an arbitrator is involved, just like the mediator, and the process is almost same. An arbitration clause is also being signed over here, but the only difference is that in mediation, always the statements or suppose the statements which are passed finally by the mediator is not always binding to the parties because it's voluntary on the party that the party can either accept the solution or they can reject the solution and they can say that they are unable to settle over this dispute, so they are going to move to the court. Or it can also happen that during the first session they could not settle in the first meeting, they want another hearing, they want another meeting date to get that settled. And it also happens that during a mediation, when the mediation process is completed and they are not getting settled by the consent of both the parties, arbitration process is being involved. And when an arbitrator gives the statement, it for certain cases it becomes binding. Now, moving on to the role of alternate dispute resolution in the legal world. Now, as I already have told that why it is beneficial, why it is the so as the best alternative of traditional litigation. Also, besides that, it eases the court congestion, that is the burden that is there on traditional court systems to give faster judgments over the matters, over the disputes. It helps to mitigate those burdens over the courts. Also, the time and cost savings. I've already told about that. That ADR process generally fast and they're much faster than the normal court proceedings, which takes years and years. But ADR does that in like few months or so, enhances the access to justice. Now, about enhancing the access to justice is that sometimes it happens in courts that uh, we obviously have to follow certain guidelines, certain court procedures. We cannot go beyond that. And we somewhere down the line know that emotions not work in court because whatever is the evidence, whatever is other statements given by the witnesses, or whatever other evidences submitted by the parties, whatever other statements or evidences collected by the investigating officers, okay, those are being recorded in the court, and accordingly, seeing the situation, seeing the past judgments, and whatever needed things, the judge passes his order. Now, in this procedure, sometimes it happens that there are some words or some statements in our mind, in our heart, which we cannot say only because we not have that particular evidence or supporting evidence rather to say it. Right. But when it comes to idea, as I've told earlier, that it is an informal way in which, uh, like, the problem can be mitigated, the dispute can be solved between both the parties. So, this is a process which makes the people, uh, just making people justice more accessible to them, and that is why it is an informal avenue for resolving disputes. And in this thing, it comes like you negotiate between each other, you tell different kind of collaborative things. Like, okay, if there is suppose an example of dispute between company A and company B. Okay, now company A had to supply a certain amount of raw materials and a certain amount of raw materials, bricks, stones, etc., for building purposes to company B. Now, company within a particular time period, that was 1 year of signing on the contract. Now, due to some recession and market criteria, company A could supply only 50% of whatever they had promised. And but on the other side, according to their contract signed, company B had already provided all the money, had already paid them all the money for the ordered raw materials. Now, pertaining to the weather conditions, pertaining to the recession period, the price of the materials has gone up, and unfortunately, there was a flood, and flood could not be predicted like that from beforehand, although it was somewhat predicted, but mostly it could not be understood that it would have such an heavy impact. So we take that as an act of God, they could not help in that. So company A could not provide the other 50% of those raw materials being ordered in the scheduled time. Now what happened is, obviously company B had already provided had paid all the money for those materials, and now they are not getting it. And obviously they will have some dispute between both of them. It's quite obvious. So company A now tells that they're ready to provide for the materials, but due to the damages they have faced according to act of court and everything, and now there was a recession period, the price of raw materials have gone up, and now that's why company B have to provide them with somewhat extra amount of money so as to procure those raw materials. So company B was not ready for it, and hence they chose for ADR. That and the process they chose was mediation. Now, in this mediation process, they told each other their problems, their own side of problems for their own perspective, and mediator in this case, not only in this kinds of cases, but any kinds of cases, the mediator and the arbitrator has to be compulsorily neutral. Why? Because if suppose the mediator becomes uh, partial to any of the party, or the mediator suppose favors company A who were to provide with the raw materials, then he would give certain solutions which would only benefit A, but as not as B, right? So in this cases, it's very important to be very neutral, to think from both the sides' perspective that what losses they have faced, or what they are trying to say, or what they are trying to mean. Now, suppose the uh, mediator gives a certain collaborative approach that the project B was working on, they had to make A a collaborative partner of it. Okay, they have to give one like a particular share, and in turn, company A would provide them with some amount of raw materials, or rather, like uh, 90 to 95% of the raw materials which were left from the rest 50%. Now, not only this, except this also, there can be many various way of creativity. There can be many various way of creative collaborations. There can be many various way of settling these disputes. And it could also happen that they were not ready to settle these disputes amongst themselves over there in that session. And maybe they have called for a second meeting. The dispute is not getting settled in the second meeting also. So they are now ready to move the court against each other for breach of contract. This is how the mediation or the arbitration process goes on. Now, if they wanted, they could even after, suppose on the second meeting, the dispute did not get solved. So they could again tell the mediator that we both want another mediation date for another mediation session so that we can resolve this dispute. Maybe only 70% of the dispute was solved, rest 30% wasn't. So for the rest 30%, they need another session. So that could be appointed. Now, after this, just like we know that everything has its pros and cons, obviously, just as area is beneficial to people, it also has its own pros and cons. These are all what was pros, that is cost effectiveness, speedy delivery of justice, then preserving relationships, informal approaches, everything. These all were somewhat the pros side of alternate dispute resolution. Now let's come to the challenges and the limitations what ADR has. Now the most important and primary challenge is ADR is such a process which is very voluntary and the participation is also voluntary. You cannot force anyone in this thing. Not even the mediator or the arbitrator can force any of the parties to take any to take his or her whatever his or her statements are, whatever his or her solutions are. The mediator or the arbitrator cannot force any of the party to take that up. It's completely voluntary. Now, when it comes to challenge, the most primary challenges, it is voluntary and the participation of the parties are also. It is that company A suppose had chosen for the ADR, the mediation process, and he has sent invitation for the mediation process to company B. Now, it could also happen that company B would not accept the mediation. Then what? They obviously had to go to the court. If the other party is not ready to accept your invitation for the mediation session. So it is one of the most primary challenge. Another thing is that suppose for the first go, the other party did not accept the mediation session invitation, you have to try convincing the other party. You have to try convincing the other party or encourage the other party or convince them to come to the ADR process. Because maybe once you have lost some of your resources, you have lost some of your financial resources also. Now, again, when it will go to the court, you have to give your finance over there, your time, and it's gonna take years to get at to the end of the case. So obviously, you will like try your heart and soul to convince the other party so that they could come to the mediation process or arbitration process or negotiation process to any. Now, the enforceability. Unlike the court judgments, which are final and binding to the party, that is, we know that if the district or sessions court gives a judgment, we can further move to the high court. And if we're not satisfied with the high court judgment, we can further move to the Supreme Court. And any judgment given over there is final and binding on both the parties. But when it comes to the mediation and arbitration or negotiation, for that matter, to any ADR process involved, those judgments or those statements which are being given by the either the mediator or the arbitrator, those are not necessarily final and binding. It is again voluntary on either of the party that if they're ready to settle or if they are not ready to settle. It also happens that maybe first party is ready, they are okay with it and they are settling, but the second party is not. Okay, so it happens. So in that case, the ADR agreements should be well drafted and they are to be drafted in such a way that they can be partly enforceable on the parties. Now, again, that thing comes that is voluntary in nature. Obviously, you can't force either of the party to accept that. Another most important thing is power, the imbalance of the power between both the parties. Sometimes it happens that the client, the client party, who is taking its raw materials or maybe any goods or anything for that purpose, the other party may be more powerful in matters of reputation, goodwill for that case. So we generally see that if a company or if a party has good reputation, goodwill in the market, then we have a kind of conception, or we perceive that okay, this firm or this company has a good reputation. It might be very good, and if the reputation goes down even, then somewhere down the line we think that the judgment, or suppose the statements will be passed for their favor. So in this thing, the other party may feel compelled that if we go totally against them, or maybe if we are not at all settling to their statements or something like that, they might cause any harm, or they might uh, cause any loss to our company in turn, just because uh, we are not in that much power as theirs. So it's the duty of the mediators and the arbitrators to make each of the party aware of their power, and also the mediator and arbitrator should also keep this in mind, so that no party, or should also ensure and keep this in mind, that no party is compelled to, like, come under this perception that okay, the other party is stronger than mine, is more powerful than mine, so I won't give my statements that much. I'll compensate and let that party, like whatever statements they are giving, will just voluntarily accept that. That should not happen. The parties should feel the neutrality. The parties should feel that they can be open in that session. They can speak out, but again, keeping in mind that they should not use any harsh words against each other, or they should not use any word that insults or tarnishes the other company's reputation. And uh, like making the parties convince this, or rather make this known, is somewhat challenging. Now, some of the limitations are, these are really not suitable for all the disputes, because some of the legal cases may be very much complex, involving more than two or three parties. So for that reason, the court orders are really needed. So in that matter, ADIA would not come to place or come to their help. Also, when the parties might not be aware that their legal case is so much complicated that they cannot be settled by area, they should be going to the court for settling it. So, in that case, if they're going to any mediator, or they are going to any arbitrator for that case, then uh, it will be the mediator or the arbitrator. It's their duty to guide the parties that this case is too complicated as to settle them in area, or by using the process of area. Now, another thing is unwillingness of cooperation. As we know that India is such a process of mediation, arbitration, or negotiation, in that case, that there has to be a certain amount of cooperativeness, collaborativeness amongst the parties, right? So, in that case, if suppose one party is not at all ready to cooperate, okay, is unwilling to cooperate with the other party, then it's the duty of the mediator or the arbitrator in that case to make them convince, to uh, make them convince as to that the other party is cooperating, other party is ready to mitigate. The party who is not, they should also, because they have voluntarily turned up for this mediation session, they were not forced to do it, right? And also, the mediator and the arbitrator should establish good ground rules, and they should mostly emphasize on the benefits of this cooperation uh, and this session, so that they can make the parties convinced that what are the good result or what are the benefits that can come out of this process, or how they can be benefited, or how it can be useful to them. Another thing which I have told earlier, that's the potential for biasness. We have to keep in mind, being an being an arbitrator or a mediator, that neutrality should be maintained strictly. As I've told about the power, that suppose company A is powerful and company B is not that powerful. Company B is very recent to the market. Okay, so company B will have this perception in their mind that okay, company A is powerful. If we are going very much against them, then they can cause any loss to us or cause any loss of reputation to us, because we know to establish a company or a startup for that reason, the goodwill is the most valuable asset of the company, of any company for that reason. So, in that case, the party might feel that the mediator or an arbitrator might favor the other party. Why? Not just because they are more powerful than us. So, that should not happen. And the mediator or the arbitrator themselves also, they should keep this in mind, not to feel anyone, not to feel anyone that they are going in favor of the other party. Okay, and not maintaining neutrality should be maintained like strictly. Next, they both the parties, they are being signed an arbitration clause and the mediation clause before the start of the session by the mediator and the arbitrator themselves. So in that case, if any of the things are violated, suppose the matter could not be settled in area or in those sessions. By taking 2 or 3 sessions also, the matter could not be settled. So both the parties decided at the end that they would now go for the trial. And in this matter, as I've said, that one of the compulsory ground rules are that confidentiality. The one party cannot use any statement used by the other party in the session or during the session in the court against them. So, if anyone is using that, it's the duty of a mediator or an arbitrator to take action against that particular party or that particular person, because it was one of the most primary rule that no such statements cannot be used against each other in the court, or whatever is being discussed in during the ADR process, that cannot be taken to the court. Now, again, some of like the when it comes to family disputes, sometimes we see that we know that various families follow different kind of cultures. Okay, when it comes to family disputes, always it's not that they are having some land disputes. They can have some of their cultural disputes also, like cultural adoption and all. So in that case, if the solution is not like the solution is compensating, or the solution is not adhering to their cultural perspective, to either of the parties cultural perspective, and they are not ready to take that up, then it is again on the mediator and the arbitrator to make the party convinced about the solution, about the beneficiaries of the solution. Because culture is something which we all like to preserve, we all love them, and uh, we can have different kind of cultures amongst ourselves. Okay, so we would love to preserve them, right? So in that case, it's very important that if either of the party thinks that their culture, some of the part of their culture isn't violated, is on the mediator and the arbitrator to resolve that, to give a better solution. Now, obviously, in this area process, not only you can go as a client or you can go as a party, but as a legal professional or a law student, You can aim towards a career as an independent mediator or an arbitrator. You can educate people, you can train them as to how to mediate the process, how to be a good mediator. You can also opt for being an independent mediator who resolves the company disputes, who resolves family disputes, who resolves the commercial disputes and everything. For that, you need to, like, you have to give a good observe, you have to get a good observation skill, a careful consideration on the nature of the dispute, as I've told earlier, that each and every legal dispute cannot be solved with idea. Some of them may be very complicated, so as to getting them solved in that particular process. So you have to keep that in mind also. And another thing is willingness of the parties. Sometimes it happens that both the parties, one party has invited, another has accepted the invitation to the mediation session or the arbitration session. But in that case, when they come to the session, one of the party who have accepted the invitation to the session, that particular party is not, ready to cooperate or is unwilling to cooperate. So that time you have to take a stand and you have to establish good ground rules so that they are not violated. You have to make them understand. You have to encourage them. You have to, convince them so that they get convinced and so as to they cooperate with the other party in settling the dispute. So that was all for today. Now, if anyone has any questions, they can surely ask.
Ma'am, good evening, ma'am.
Good evening.
Ma'am, if the parties actually take the matter, no, the matter that is discussed into court, is there any law that is binding to them?
It's not law certain binding to them. If suppose, uh, as a mediator or an arbitrator, you will be making them sign a clause, which will include this clause that they have to maintain confidentiality and they cannot take any statement or they cannot use any statement rather against the other party in the court. Right. So in that case, if they're breaching that particular clause, obviously there will be certain provisions in law so as to punish them.
Yes, ma'am. Thank you, ma'am.
Okay, thank you. What kind of cases which binds a certain decisions in arbitration? That depends on the types of the cases. Like I said that the family dispute cases which are not very complicated, those can be binded. Yeah, negotiation is the process where both the parties are being involved for the consent issue. Now, this are one of the steps besides arbitration and mediation, which are being taken by both the parties to resolve the issues before taking to the court. Now, one particular party has to send invitation to the other party to invite them in the process, and it's voluntarily on the other party as to whether they will accept the invitation or they won't. And in this thing, as I've told earlier, that this process is speedy, cost effective, and also at the same time, uh, it maintains the confidentiality that any statement or maybe you have done a mistake and you've accepted that during the negotiation process that cannot be used against you in the court. So you're getting this benefit. Anything else?
If anyone have a question, kindly unmute yourself and ask. You can also write in the chat box.
Ma'am, if you want to pursue mediation, arbitration, or a negotiation as career, so how we can start in that after completing our BLLB course? Like how we can look forward to it?
Mm. So, there are not only like after this, completing the course, but before that, we are already like pursuing certain internships, right? So, in that case, you can obviously pursue certain area internships which are available at various firms so that you get to work with their committee or you get to work with a cell accordingly. And over there, you can get an option or you can get an opportunity so as to make it as a career.
Ma'am, there is a question by Tanik Bana. Is the decision made in arbitration is legally binding? Question mark.
No, the decision made in arbitration is not legally binding. As I've said, that decisions made in courts are legally binding, but when it comes to area, not all the decisions are not binding. Why? Because it is again in voluntary in nature and depends on the parties that whether they will accept the decision made by the arbitrator or mediator during the process. The mediator or the arbitrator in that case cannot force them anyway so as to accept their decision.
Uh, Thank you so much, ma'am, for a wonderful session. Now I would like to call Sakshi Sharma, ma'am, for vote of thanks.
Uh, Firstly, good evening, everyone, and a very happy Diwali to everyone in advance, and especially to you, ma'am. Thank you so much for taking out your precious time and joining this session, and for teaching everyone on ADR. It definitely was an interesting session, and you covered it very thoroughly. And you've also answered question with such, I'd say, preciseness that everyone has understood everything. So thank you so much, ma'am, and thank you to all the participants who have joined today. And once again, a very happy Diwali to everyone. And also, I request everyone to kindly please fill the feedback format as it really helps us and all our speakers as well. Thank you so much, everyone.